Welcome to Immigration Quicktake. This is Ellie Rutledge with the American Immigration Lawyers Association. For the past few months, Marylanders have been working to get a bill passed into law that would extend jurisdiction for guardianship and custody proceedings to special immigrant juveniles, or SIJS, eligible individuals over 18 and not yet 21. Foreign children in the United States who have been abused, abandoned, or neglected may be eligible for SIJS. However, in years past, eligibility ended at age 18. Recently, Maryland Governor O'Malley signed the bill into law, allowing those 18 to 21 years old to take part in SIJS benefits. With me today is Michelle Mendez, AILA member and immigration attorney in Washington, D.C., to tell us more about the new bill. Michelle, thanks for joining me. First off, what has the issue of aging out meant for children?
So to be eligible for special immigrant juvenile status, one must be a child, which under federal law is defined as someone who is under 21 years of age and unmarried. However, in order to file for SIJS status using the Form I-360 with SIJS, one must first get an order from a juvenile court. In order to get an order from the juvenile court, one must be usually, as in most states, 18 years old or younger, because the age of majority in most states is the age of 18. And so for those minors who reach the age of 18, they're not able to get an SIJS factual findings order from the juvenile court judge. That creates a gap between 18 and 21 years of age and disadvantages a lot of the minors who would otherwise be eligible for special immigrant juvenile status.
Thanks, Michelle. How did this bill come into fruition?
In Maryland, we were able to have a bill signed into law by Governor O'Malley, and that law allows jurisdiction with the juvenile courts to expand up until the age of 21, as long as the minor is unmarried, for guardianship and custody cases that are filed in conjunction with the motion for special immigrant juvenile status factual findings. This came to fruition because we were able to find a legislator that would be sympathetic to the cause. That legislator ended up being the mayor of Baltimore City, Mayor Stephanie Rawlings Blake.
What do you see this bill doing for children who are SIJS eligible moving forward?
This bill in Maryland, HB 315, which comes into effect on October 1st, 2014, will allow a lot of minors who would otherwise not be eligible to get into juvenile court because they've reached the age of 18, now have a better opportunity, longer opportunity, to find an attorney, to get the case prepared, to navigate the legal system and a lot of the other hurdles that normally kept a lot of these minors from benefiting from SIJS because they had already reached the age of 18.
Based on your experience, how can attorneys follow suit in other parts of the country?
What we would suggest to other attorneys, other AILA attorneys specifically in other states who want to propose similar legislation in their states, is to find a legislator, a lawmaker who would be sympathetic to the cause and who would be willing to propose such a bill in their legislative package. And to also do some background research as to other legislators who would be sympathetic. For example, we had a champion in both the House of Delegates and the Senate who ensured that the bill would pass both chambers. So find some non-traditional allies and propose this more as a family law issue that really benefits your state as a whole, and which in fact it does, and it will.
Thank you, Michelle, for joining us. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.